Welcome once again to Lehto's Law. Here's Steve Lehto.
Wild story out of Pennsylvania, the whole bunch of twists and turns. Several people sent it to me. A $31,000 car repair bill. But the garage owner missed the chance to fight the lawsuit by the customer who says he was gouged, and that's according to a higher court in Pennsylvania. So several people sent me the story. It's from Penn Live. Matt Miller wrote it. And it has to do with an auto repair facility. A state appeals court panel has refused to let the Pennsylvania garage owner have a chance at trying to overturn a $134,000 judgment that was achieved against him in court because the allegation is that he gouged an elderly man on an auto repair. So, man brings his car into the shop for repairs. It gets worked on, and then the man gets billed by the repair facility for $31,500. The man later says, I was gouged, those repairs were not necessary, I was overcharged. He files a lawsuit. The lawsuit results in a judgment for $134,000. That's what the garage owner is trying to fight right now. So the man who owns the General Auto Repair facility is facing that $134,000 judgment after failing to respond to a lawsuit filed by a customer who claimed he was wrongly charged $31,500 for unneeded repairs to his 9-year-old Toyota Camry. And that sentence alone is so loaded that it makes you think maybe there was something to this case. $31,500 to repair a 9-year-old Camry. But you'll know the first half of that sentence is the failure to respond. So if you ever get sued, a lawsuit is filed against you, you will be served with a summons and a complaint in most states. The complaint is the lawsuit. The summons is the court order that accompanies it that says, in essence, this is a real lawsuit and it's been filed with the court and you need to do certain things. And in Michigan, it actually has 3 things spelled out. It goes, you are being sued. You need to respond to this lawsuit. And we recommend you hire an attorney. And it says right on there, if you do not respond, a judgment can be taken against you. And it's bad if you do not respond. So if you do not respond, bad things will happen to you. So at the very least, don't ever sit on a summons and complaint and think, I wonder what I'm going to do. No, you need to respond. So contact an attorney or ask some, friends of yours, do you know an attorney I can speak to? But eventually speak to an attorney and find out, because they will explain to you that there's a time frame. And if you do not respond, you can be defaulted, which means that the court will assume, well, you didn't fight it. You knew about it, right? You were served. You must just concede that everything in the complaint is true, and then you'll be defaulted. That's what a default means. So they'll get everything they're asking for. You don't ever want that to happen unless you really are willing to concede that, yes, I owe them everything. So in refusing to reopen and revisit the case, the Superior Court judges agreed with the Lancaster County judge that the shop owner missed legal deadlines for challenging the lawsuit filed by the man from Millersville. The man was 79 at the time, and he claimed that the garage wrongly advised him that the engine and transmission of his 2011 Camry had to be replaced at a cost of $31,500. And that's when the man brought his car into the shop for an inspection in January of 2020. So the judge, writing in the Superior Court's opinion, said, the man paid that amount in 8 checks to gain release of his car. He says that the garage never performed the extensive repairs to his vehicle and that the costs exceeded the then average price of a brand new Toyota Camry. And so you might wonder why someone would pay an outrageous bill to get their car back. Well, I'm sure you know that in many states, a shop that works on the car has a lien on the car for the work they performed. And so they can hold on to your car. So we're not going to give it back to you until they pay us. So some people will pay the money to get the car back and then follow up on it later, but they want to get their car back. So the garage owner was served with notice of the lawsuit in July of 2020. So notice of the lawsuit, I assume, is the summons and complaint. He did not respond to it at all, apparently. He said a default judgment was filed a month later. So he served in July. The default was filed a month later. And that's pretty much how it works. Most courts, I hear about, say you get 21 days or 28 days. I've heard of 30. But it's usually a few weeks to a month to respond to the complaints. You got time. And so, if you're out of the country or something, I understand you might have a problem. But of course, if you're out of the country, they can't really serve you, can they? So if they got good service on you and you're around, you got 3 weeks, 4 weeks to respond to the complaint. So the man who was the consumer here sought not only repayment of the bogus repair bill, that's what he called it, but also more than $100,000 in damages and attorney fees. We're not sure what the attorney fees are broken out of this. They can't be that much because presumably there was, the initial work where you meet with the client, you draft a complaint, you file the complaint, and then you file the default and you seek the judgment. That's not a whole lot of work. I mean, it's some work, but it's not a lot of work. That's the least work you can put into a successful lawsuit for the most part. I've actually had some that were simpler than that, but another story. So, lawsuit was served in July. Default was entered in August. And in September, the garage owner finally came around and filed a petition to reopen the case so he could belatedly challenge the claims. And when that was denied, he then appealed to the Superior Court after the county judge denied the request. So, in Michigan, for example, if someone gets a default against you, you can seek to have the default set aside. You got to go to court and say the default was entered. Here's why I need to have it set aside. And you can't just say, well, I just forgot. I was not paying attention. Now, I've seen judges actually set defaults aside for that reason. They're not supposed to, but they do. But generally speaking, the court rules say a default can only be set aside when the person who's been defaulted shows good cause as to why it should be set aside. Some good reason, such as I wasn't actually served. That's a good reason, and so on. Now, then, obviously, if you get the default set aside, all that matters then is you just go to court and you fight the case. It doesn't mean that you win the case. It just means that you have the right to go in and fight this. But they're saying, hey, look, the guy got the default entered against him, and he didn't even respond to that in time. So this judge, on appeal, did not buy the argument any more than the lower court judge did. So the judge wrote, he asserts that he encountered difficulty in retaining counsel because of the COVID-19 pandemic. Well, a lot of things got more difficult during the pandemic, but attorneys are around. You can call attorneys on the phone. You don't need to see them face to face. So I've had people call my office before and say, hey, Steve, I got a question for you. I have a problem. I've been served with a lawsuit. What do I do? That happens. And so the man says he encountered difficulty in retaining counsel. And then he said that, this is what the garage keeper said, he consulted with at least 10 lawyers about the case and possible bankruptcy before finding an attorney to represent him. So there's two things going on there. But he says he spoke to 10 different lawyers, at least 10. And I can tell you, I've had someone come in my office before with a summons and complaint and show it to me and say, look, I'm being sued. And I say, okay. And I talk about it with them. And I don't do much defense work at all anymore. But I used to a long time ago. I'd handle all kinds of stuff. And when someone was in my office, I would say, when were you served? And they'd tell me. I'd say, here's the thing. Just to let you know, the clock is ticking right now. You got served on that date. Here's where you have to file the answer. And we've got to do this. And just so you know, when you walk out the door of my office, if you don't hire me, you got to hire somebody, or you can file an answer yourself. There's no law that says you have to hire an attorney. I've seen litigants who are not attorneys file their own stuff, and it can run the entire spectrum. I've seen gibberish filed by people, and I've seen extremely polished stuff filed by people, and the law simply says you must respond, and there's some basic court rules. You got to respond in writing, and you have to answer the allegations in the complaint, and there's some tricks to that, but it ain't that tricky. So the judge writing for the appellate court cited the contention that he consulted at least 10 lawyers about the case and possible bankruptcy, but by law, the man had 10 days to challenge the default judgment. And by the way, the default judgment is different than technically the default is. So when you get served with a complaint, you're being sued. You don't answer it. So they go to court and they ask for a default. And the default itself is simply the legal ruling that says this person has not answered and is therefore barred from answering. Then you can ask for a default judgment. It's true that a lot of people ask for both of them at the same time, but they're actually technically two different things. The point is that under Pennsylvania law, apparently, you've got 10 days to challenge a default judgment. Okay. And apparently he didn't do that until a month later. So he missed that deadline by 2 or 3 weeks. Okay. So the judge wrote a 4-week delay between notice of the entry of default judgment and filing of the petition to open was not prompt. The judge noted that the garage owner could have at least started his challenge to the complaint without a lawyer. While circumstances surrounding the COVID-19 pandemic may have contributed to his difficulty in finding representation, it does not explain why he did not take any action himself, the state judge wrote. So the point is that if you get served with a summons and a complaint, those deadlines are drop dead. Those are serious deadlines. And so right now there is a repair facility owner in Pennsylvania who charged a man apparently $31,502 to do an engine and trans swap on a 2011 Camry. And the consumer thought that was a ripoff and sued him, and he didn't respond in time and got a default judgment against him for $134,000. And that appears to have happened largely because he didn't answer the complaint at all and didn't respond to the default judgment in time. So very, very serious things. And if you're going to call 10 lawyers about representation, you might want to ask them, do you have any idea what's going to happen to me if I don't respond on this date? Because they'll tell you that over the phone. I'd tell you that. I'd yell it at you. Make sure you understood that. So there you go. $31,000 car repair bill. Garage owner missed a chance to fight the lawsuit by the customer who says he was gouged, according to the Pennsylvania court. Matt Miller wrote for PennLive.com. Jonathan, Michael, and Denton all sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Do not argue with the inevitable.